The lawyer is basically a team leader in problem solving. The team will depend on the setting. In the homeowner association field, the team might be the insurance agent, the board members, the association manager, different teams in different fields. The lawyer's role is to help be the facilitator to come up with creative solutions to problems.
I think a lawyer has to be very astute to the whole body of sociological and psychological environment in which one lives. Affects one's, the client's desires, expectations, hopes, and whether the lawyer can solve them before they become serious litigation-type problems.
More often, the lawyer can be a problem solver of helping people avoid problems, or where the problems can't be avoided, of thinking about where the goals of where the client wants to go, what the goals of the client are, and creating mechanisms for getting there.
When most attorneys contemplate how to live and operate in a problem-solving and designer mode, they start to think in a fast-forward way. In a legal system that's based on reaction, backward-looking, lawyers end up being tossed around by events. They're reactive. They're the object, and the environment out there that has already happened. The facts, as it were, the cold facts, push lawyers around. In a fast-forward mode that's prospective, that's looking ahead, lawyers are no longer being pushed around by cold facts. Instead, the lawyers become the planful shapers of an environment. They're the ones in control. All the facts become hot facts, capable of being shaped in your hands.
I think as lawyers we're initially trained, or at least the image has been, to rattle the saber and to charge forward and advocate for your client in an adversarial manner. But I think as you get out and start practicing and realize that a lot of times that's not always the best solution, that in a lot of circumstances the client doesn't necessarily want to get into a adversarial posture, and instead they just want a good solution. And a lot of times that solution is doing preventive planning. Let's talk about what can be done before going to court, or before getting into an entrenched position where it's going to be difficult to have a meeting of the minds and to come to the table and resolve it in an amicable fashion.
Preventive lawyers have to have their eyes, you know, if you use a driving analogy, they've got to have their eyes looking down the road about 6 exits on the interstate. Versus lawyers who are doing something besides preventive law, they aren't looking down the road at all. They're looking at the accident we had at the last interchange. And you know, and the question is, had there been preventive law practiced, would we have avoided the accident entirely and still be continuing our drive?
Problems have kind of a life history. They have a beginning, they have a middle, and they have an end point. More importantly, they have antecedents. If your antecedents begin here, that's where a lawyer can operate effectively as a designer, as a preventive lawyer, constructing an environment so that the problem never even begins. But once the problem has begun, I still may be able to act as a problem solver and tinker with the environment so as to resolve the problem creatively. I can still look back a little bit into the tape, and I can look forward, in a sense, to make sure that the problem doesn't recur. Once I get to the late stages of the life history of a problem, once I get into litigation, the only way I can operate is in a rewind mode, looking backwards historically. There's no place else to go.